Welcome to the Three Questions webcast series. I'm Wayne Baxter, Senior Executive Manager with One Capital Management. On this edition of the webcast, we're going to be asking the three questions you should ask about community property laws before filing a divorce. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions webcast series, please consider liking this video and subscribing to our YouTube channel. Now, at One Capital Management, we develop and implement strategies for our clients which strive to grow, protect, and ultimately distribute their wealth. And we do that by offering investment wealth management services. And my clients are often referred to as cross-border clients. Now, why would that be? Well, it's because they're either U.S. or Canadian residents who invest in U.S. and or Canadian dollar-denominated securities like stocks, bonds, and ETFs. Our process for advising our clients includes an in-depth discovery and diagnostic analysis of their wealth management goals and objectives, and as one would imagine, in some cases, a discussion about an upcoming divorce could be a part of that, overall discussion. And if you live in a community property state like California, there'll most certainly be a discussion about how property investment will be divided between spouses. On this episode of the webcast, we're going to speak to a forensic accountant to discuss the community property laws and how they could impact a marital dissolution. On this edition of the webcast, we're going to be asking the three questions you should ask about community property laws before filing a divorce. Joining me from Burbank, California, is Linda Schauer. She is the owner of Linda Schauer Forensic CPA and Associates. In addition to her CPA designation, Linda is also a certified valuation analyst and a chartered global management accountant. She specializes in forensic accounting and litigation support services for family law and civil matters. She has over 24 years of experience in both public and private accounting. Linda, great to see you again. Thank you for taking time to join us.
Good to see you, Wayne. How are you?
Wonderful. It's great to see you. And in preparing for our webcast, you were kind enough to remind me of one of our very first discussions about, well, I must admit, I was really interested in what you did. The whole idea of forensic accounting in family law, for whatever reason, I felt was really interesting. And we actually had an initial case where it was actually a potential client of mine who reached out to me because she was going to be inheriting money from her mother's estate, and I believe it was in Quebec. It may have been Ontario, but I'll say I think it was in Quebec. And you were quick to remind me of some very important matters, and maybe you could actually just chime in on what that was.
Sure. You had mentioned that this client was inheriting these funds and that they were married here in California. So I wanted to just make sure you were aware that to the extent that that property or funds were her separate property, it's important that those monies be kept separate and not commingled with community funds. So that was the main thing, and making sure to have the documentation related to the gift or inheritance. Those documentations would be vital because in California, it's a community property state. So if you want me to delve in, I can.
Yeah, why don't you just give us the, now we're in the United States, not to use Cliff Notes as opposed to Coles Notes, as we used to say back in Canada. So maybe you can give me the Cliff Notes, or give us the Cliff Notes version of the relevance of community property states.
Sure. So in California, as a community property law, basically all the income that you earn during the marital period, money that you've earned, is considered community property. Anything bought with money that you earned during the marriage is considered, and it's presumptively community property. Also, any debts acquired, and that would be by either spouse. Differentiating from the separate property, which is governed by the family code. Separate property of married people are anything that was owned prior to marriage, acquired by marriage or during marriage, by gift, inheritance, so forth. And then also any rents, issues, or profits from that separate property that is owned by that separatizer are considered separate. So given California has these unique in the sense that not all the states in the United States are community property, it's something that's pretty important in terms of how you handle it during the marriage and then how it's documented.
So it's inherent upon someone in California to have multiple bank accounts. So that means that they're receiving proceeds that are coming from their own resources to go in a separate bank account than just a general joint bank account for the couple. Would you agree with that?
Yes, to the extent that they can maintain those separate funds and not commingle it with any funds that are earned during the marriage, because the burden is on the separatizer, given that the presumption in California is that it's a community property asset or debt until proven otherwise.
All right. Well, I remember we met for lunch over in Sherman Oaks one day, and we had this conversation. This is something really interesting, and must admit, I'm glad we met. And I got to tell you, I did do a little bit of research and due diligence to prepare us. And one of the things I discovered, and this actually came from divorce.com, who we will hope is fairly accurate in their assessments. They said that the highest number of divorced men, and we're going to talk about California today, by the way, the highest number of divorced men in California are age 65 or over. So I guess we're referring to what they call now the graying divorce or gray divorce. And I think it would be safe to say that given the accumulation of wealth amongst that demographic, the 65 and older, would it be safe to assume that this demographic is the ones who are most likely to seek out your services? Would that be a given?
There's definitely been an increase in gray divorces lately. However, I think also there's statistics that, for every marriage, at least 50% of them will end in divorce. So it's also the age or demographics are varied. People often ask me, do more men or more women reach out for my services? And frankly, it's both. I can't say that I have one more than the other, but there is statistics that more women are applying for the divorce, but not necessarily in the age bracket that you mentioned.
All right. Interesting. So, well, I know we got a lot to unpack here. We could take this off into so many different. So, okay, I got to ask one question before we go ahead. You said 50%. Now, is that California or across the U.S.?
Across the U.S.
Across the U.S. Okay, I just wanted to. California was more so than any other state. Okay, so we're saying, generally speaking, across the United States, about 50% of marriages end in divorce.
Yes.
All right, got it. Okay, so I know, as I said, we have a lot to go over here, and why don't we just get right to the 3 questions you should ask about community property laws before filing a divorce? The first question, and again, we're gonna do this from the concept of married couples in California, just to be clear here, community property. So if either me or my spouse have separate property acquired prior to our marriage, how does that affect the divorce? Question number 1.
So it impacts the divorce because one, we're trying to determine what characterization to apply to any assets and debts. And the characterization would be separate versus community. So then we have to look at the evidence provided documentation. But we're trying to, first, the presumption here in California is that any assets and debts acquired during marriage are considered community property. And it is a separatizer who has the burden to prove or provide any documentation and evidence or analysis that their separate property, that there's property that exists prior to marriage or during marriage that was received by inheritance or by gift. And those details require significant analysis and understanding and, frankly, documentation. And so types of separate property would include maybe there's rental income or rental property. There could be a marital residence. And to the extent each of those are impacted, for example, if there's a rental income and that property was held by one of the parties, those rents are considered the separatizer's separate property if the rents are sufficient to cover the expenses. So that's one of the things. And also it would be important to keep that rental income separate and not commingled with community funds.
Okay, I got to ask one question before we go any further, just for clarification purposes. You've used the term a couple times, separatizer. Could you define who the separatizer is in this discussion?
The spouse that's claiming that they have separate property.
Okay, I just wanted to be clear because somebody listening for the first time going, separatizer? Like, I don't want to assume too much here. Okay, so that's
Right.
good. Okay, so again, I'll go back to the same point I made earlier in terms of when you're receiving money that is derived from your own resources, and you're receiving income, that money needs to go into a separate account than the joint account. Would that does make logical sense, no? You don't
Correct.
want
It would be important that any expenses related to the separate asset are paid from that same source, keeping the accounting and the transactions separate from the community earnings.
so I'm going to go out on a limb here and imagine that one of the reasons people contact you is because they didn't do that.
Correct. They didn't do it, or there is questions related to that. That's a big area that we have to deal with, because if the community does have contributions, there's reimbursement claims, but the more important is related to the better example, if you will, is the marital residence. There's a residence that the parties lived in. If one of the spouses owned it prior to marriage, all of the earnings by both parties or the community, regardless of who is employed outside the home, are considered community property.
Mm-hmm.
Therefore, if the community is paying the mortgage on one of the spouse's separate property, the community is first entitled to reimbursement. But not only that, according to the family law code, there is a component where the community receives an appreciative interest. And there are different case laws on how that interest is calculated. So to the extent that the community contributed during the marriage to this separate property, they get both a reimbursement of their principal payments made during the marriage. In addition, there is a calculation made that gives them an appreciative interest to date of trial, or at the point in time the divorce is being finalized. That's not, contrary to some people think, it ends at date of separation, and it does not. It goes through the property either at trial or when the divorce is being finalized.
So you will often, I would imagine, be brought in as almost like the expert witness here. When a case does go to court, if there's litigation, you must be a part of at least one side of the discussion, representation of making their case in front of a judge.
Correct. I am often called to first perform the calculations and analysis, evaluating all of the documentation available and provided. And if needed, I will assist with either settlement discussions, mediation, or ultimately, if it goes to trial, I will testify in court.
And this could be anywhere, just to make a note of this could be anywhere, not just within driving distance of Burbank. I would assume this could be anywhere in like LA, Ventura County, down Orange County. Like, generally speaking, you have a fairly decently wide range of.
It's California, so generally I haven't been retained higher than, I think, San Jose.
Which is Northern California for those folks.
But for the most part, I'm retained in Palm Desert, San Diego, anywhere in LA County, Ventura. That's primarily where I've been testifying.
Again, for those folks not here in California, once you get, I guess, up towards San Jose, Silicon Valley area, that's considered Northern California versus Southern. There isn't an actual border, but there's at least a supposed border between Northern California and Southern California.
So another area
philosophically and otherwise. But just okay. So you wanted to share one more thing before I go to my second?
did, regarding the residence. If during the marriage there are refinances, that poses an additional complication, and it's really important to understand that if a refinance becomes a transmutation, they need to make sure that they understand that transmutating changes the character of the property from separate to community.
Interesting.
And if that is not their intention, then one of the spouses who is not the owner of the separate property will and should be asked to sign an interspousal transfer deed. That is the only document currently that reflects that they understand that this property is not a transmutation and that the character and the property is not going to transmutate to community. There's specific language according to the Family Code section 852 that explains that this language is required to be explicit and clear. And that is the only deed that would be valid at this point, at least since that case law. There's case law that came about that basically said that language is very important. So any refinances or, it's very important that the parties understand if their intent is to actually characterize the property and transmutate it from separate to community, or if they really intend to keep that property, they're separate, they need to have the interspousal transfer deed signed by the other spouse.
At the risk of going down a way deeper rabbit hole, this assumes, of course, as well, that both of them are using their financial might to get the financing, right? In other words, both people are basically.
That's another issue. Thank you.
There
is
you
that
go.
At the point of refinance, prior, there was likely a separate property debt that had been acquired when the property was initially obtained by the separate property separatizer, if you will. And then when there is a refinance during marriage, what needs to be considered is what the lender intent was and what they relied upon to get the new loan. Typically, and most often, the lender relies upon the community earnings. Therefore, at that point, typically, the loan becomes a community property debt, and therefore the community obtains a significantly more appreciative interest in the property.
Interesting. So to keep things completely separate, you would almost say that the community, the individual owner of that property should be doing the financing on their own if they want to keep it clean. Would you agree? Or am I overly overthinking this?
It's generally not possible for them to obtain the financing unless they have sufficient funds to have only their separate property funds considered for the new loan.
If they did, it would be in their best interest to do it that way.
It would be in their best interest. I did have a case that I can share with you. It is now done, where the husband had significant investments and separate property where he utilized a loan and secured it against his separate property bank brokerage account funds to obtain this loan to pay for the down payment of a home he acquired during marriage. So therefore, that was deemed his separate property.
Wow.
Loan.
You have a fun job, Linda. Okay,
it's
question
pretty interesting.
Yeah, this is really good. We could have like 2-hour lunches.
yeah. It's
with no alcohol. I mean, well, all right. So question number 2. My spouse and I own a business together. How is that handled during a divorce from a perspective of A, valuation, B, income, and C, operation and management roles? I cannot wait to hear about this. This is going to be good.
Not sure this is enough time. A business.
We don't have a clock on this one, so you're good.
So a business has to be looked at, again, the character of the business. So we have to look at, was the business owned prior to marriage or was it started during the marriage? Sometimes the business had existed as a sole proprietorship before marriage, but maybe they decided to incorporate it for tax reasons or so forth. And so during the marriage, they incorporated it. But the main distinction is whether or not it's the same business. And so first is it's considered community property to the extent it was created during marriage. But more importantly, let's focus on just the business aspects. We have a business that provides, let's say it's a separate property business. We'll start with that. And any income that separate property earns, in general, that income and use of that income during the marriage is considered community property. So we have to look at, in terms of the income that the business generates for income available in the calculation for and determination of spousal or child support. So when we look at the business records, we have to look at the profits and really look through all the expenses to determine whether or not there's perquisites, which are personal expenses paid through the business. We would be making adjustments, and we would also look at various looking at tax returns, bank accounts, and really analyze to see what is their gross income available for support. So that's one piece of it. Then we have to look at, in equalizing the estate, we have to look at the determination of the value of that business. Now, oftentimes I'm asked, well, I'm the business. However, in California, it's a community property state, and we are here to equalize the community property assets and debts. Therefore, we have to value the business and attribute a value to it that may or may not reflect what you could get on the fair marketplace, if you will. There may not be a fair marketplace. However, we do have to calculate some value to attribute in order to equalize that particular.
But sometimes there's not assets, right? Sometimes it's simply a service.
Correct. However, it is still potentially a business that would need to be divided, and that community interest needs to be.
But that's where that valuation service that you provide comes in, because sometimes there's not simply a matter of quantifying a building. It could be actually just a service offered and fees charged, right?
Correct. So we look at that and we analyze and provide a value. And there's two types of valuations that's typically done. One is not provided to be for testimony. It's called a calculation of value. And that's less expensive, less detailed. There's criteria that considers that it's intended to help people settle the case and hopefully not go to trial. I do not testify based upon calculation of value reports. Otherwise, if it intends to go to trial, we would need to do a conclusion of value, which provides my opinion as to what the value of the business is. And so therefore, valuing the business is also another component of the business aspect. Depending upon whether it's separate or community, there's also considerations of, did both spouses work in the business? How does the spouse who runs the business or who will continue to keep it, how are they compensated? Do they receive salary in the business, or do they just take draws or distributions? So all of those things are considered both in the determination of their income available and in the valuation of the business.
Okay, I got a follow-up question, sort of unrelated, in talking about valuation. Are you ever brought in or hired by people who are simply looking to find the value of their business? There's no divorce, there's no disputing. It's just they hear about your services. They are you ever involved in that type of work, or do you leave that for other people?
No, I do that work. If someone, I recently did a valuation where the one of the managers at an engineering company wanted to give shares to employees, and so they wanted the value of the business in order to decide how much shares and what the value of those shares would be to other business associates. Sometimes I've had to do valuations related to shareholder disputes and buy-sell agreements and so forth. So I don't do as much of that work, mostly because family law keeps me very busy.
No kidding.
But I am sometimes called to do that work, and it's kind of nice to get out of the conflicts of family law sometimes.
Yeah, with 50% of marriages ending in divorce, I can see where your work could be ongoing and forever. I thought I would ask. I'm listening to an audiobook here recently on the life and times of Howard Hughes. And his method for finding out what his business was worth back in the 1940s and 50s was telling prospective buyers that he was selling, and he would get them all the way to where they are ready to close, and he would always back out. And the only reason he was doing it was to find out what his business interests were worth. That was his valuation process.
It's definitely,
it seems a lot less painful. I was going to say, it's a lot less painful to have someone do a valuation process than basically burn bridges as you go through your professional life. But
So,
anyway,
so one point to that is, to your point, is that, however, if after date of separation, the party who's operating the business is not operating it to its potential and is not running the business in the interest of the community, it's possible to seek an alternative valuation date because, let's say, a year or so down the road, the business is not worth as much. And then all of a sudden the claim is, well, let's just sell it. And you're not going to get the same value because of maybe actions that were taken after separation that reduce the value. So it's possible to seek an alternative valuation date, and the court can make a decision whether or
interesting.
not
Okay.
the value of the business will be
Because
prior
somebody
to
could maybe
the.
potentially intentionally try to burn the business into the ground. And I mean, there could always be,
Absolutely.
sorry for me being a cynic world, but what can I say? Things happen, right?
It's a reality. It is a
Yeah,
reality.
darn right. We've
Yeah.
learned that. We're okay. You know what? Let's get to the question. Linda, your great answer. Thank you. Very detailed, not
Great.
surprising. Uh, okay, so this third question, um, you're not going to be surprised about, given the fact that we're in the wealth management investment world, but I'm going to ask it anyway. So, if either my spouse or I were to have significant investment assets, i.e., stocks, bonds, ETFs, mutual funds, probably could add variable annuities to that we required prior to our marriage, how would they be handled if we were to dissolve our marriage? Even a general overview would be appreciated on this one.
Sure. I mean, much to the conversation when we first met, to the extent those separate assets are held prior to marriage, the question is, if it is your intent to keep those assets separate, then it's important that they maintain them separate and not commingle them. Many people, maybe after or during marriage, contribute to a 401k, contribute to some retirement on their, an IRA or so forth, and they don't realize by commingling it with separate asset accounts, it is their burden to prove that they had the separate assets prior to marriage. So documentation prior to marriage of what assets exist in those funds, and in addition to that, keeping them separate from any contributions or money that's invested during the marriage into new accounts would be my recommendation.
Wise. I gotta ask though. So this is kind of an overall. Remember, I asked you earlier about services throughout California. So if a person who's a non-resident of California has property in California, or they have or their partner is in California, would you be allowed to? Can you represent them in that case, even though they're not a resident? If they have property here, is it the property or the client that determines whether or not you can be involved?
The issue is where is the jurisdiction on their marital dissolution, if that's what you're referring to? Is this, if they reside in another state, their jurisdiction is likely in another state for handling
Okay,
the division of that.
even if
So
the property is here in California.
I believe so. I don't
Okay,
have, yeah. I mean, I've have currently the cases that I've had where the property is in the other states, they've been community property states. So it just depends. It wasn't an issue because the jurisdiction for the parties were here in California, and therefore there was really no issue with the property out of state. It's considered.
I thought I would ask.
Yeah.
Okay, so just before we wrap up here, we did a great job. I think you did a great job sort of providing some clarity and guidance here in what's involved for those who are maybe potentially are in an issue where they have property that they require prior to marriage, or they just realize that maybe their marriage is coming to an end and they want to make sure that everything works out fairly for everybody. For those folks interested in contacting you and maybe getting a chance to work with you, what is the best way for them to reach you? How should they do it?
So I think first I would suggest go to my website. It's lyndacpa.com. Linda is spelled LYNDACPA.com.
Right.
Alternatively, you can reach me on my direct number, which is area code 818-639-4042. And if they go on my website, you can fill out a form and I will respond by email or telephone.
Linda, I want to thank you again for making time to join us today. You were awesome, as I knew you would be. Linda Schauer is the owner of Linda Schauer Forensic CPA and Associates. Linda, thanks a lot for making time to join us today.
You're welcome. Nice talking with you, Wayne.
I look forward to bringing you the 3 question webcasts, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive notification of when our latest webcasts have been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meetwithwayne. Thank you and see you soon.